Hello and welcome to a special interview for The Wire supported by Glenlivet Books. Now, we've got used to thinking of Jawaharlal Nehru as the architect of our democracy, the guardian of our constitution. But a book published earlier this year suggests that with the first amendment to the constitution, which he passed just 16 months after it came into being, Nehru gutted the constitution. In fact, he mauled it. And here's the book. It's called 16 Stormy Days. And to discuss this new interpretation of Jawaharlal Nehru, I have with me the author of the book, Tripurdaman Singh. Tripurdaman Singh, let's start with what you write about Nehru's motivation for wanting to pass the First Amendment. You say it was because of his belief that the original constitution was blocking his reforms and his policies. You write, Zamindars, businessmen, editors and concerned individuals had repeatedly taken the central and state governments to court, and the courts had come down heavily on the side of the citizens and struck mighty blows against the government. Give me a sense of the sort of policies, the sort of reforms that got blocked by the courts.
So there were three tracks really that the courts had blocked. The first was to do with freedom of speech. So the government had been using public safety acts to circumscribe speech that they disagreed with, both from the left and from the right. And then you had Zamindari abolition, which was a sort of core part of the Congress program, which had been, I wouldn't say blocked, but obstructed by the courts, which was to do with the right to property. And then the third track was reservations, where the court had struck down community-based quotas as unconstitutional because they violated the right to equality and the right to freedom from discrimination.
I'll come to each of these one by one, but the first thing that I want to touch on is that your book clearly establishes that with the First Amendment, Nehru established the precedent of amending the Constitution to overturn court judgments which he found unfavorable or which were adverse to his government's policies. And that is a practice that was then followed by his successors in a much bigger way, and by his daughter Indira Gandhi in particular. But it seems he set the ball rolling down this road.
He did. He established the precedent, and this was one of the big criticisms that was leveled against him, was the fact that this precedent was being established. So it was leveled by political opponents across the spectrum. But this was also not the most problematic thing. The most problematic thing also was the sort of justification that he gave for why the amendment was necessary. So his reasoning went that he or his government had promised the people something that was now being held back by the Constitution, ergo that was a denial of democracy, and therefore what was needed was a constitutional amendment to give vent to what he thought was the will of the people. And that, in a way, legitimized a kind of particular reading of the Constitution, which saw it as something that could be manipulated, that could be evaded, that could be amended basically at any point where popular policy, so to speak, clashed with constitutional obligation.
Let me pick up on something that's latent in that answer of yours. Literally within 16 months of the Constitution being implemented, Nehru had decided that it had become an obstacle, that it needed to be amended, and that it could be amended to give priority to his government's policies over the principles contained in the Constitution. Doesn't that suggest that his commitment to his own Constitution was less than one imagined it would be?
That's what my reading of it is, and that's what a lot of his contemporaries believed. There are some who would argue that the Constitution itself, or the Indian state itself, was a vehicle for a particular end, and certainly that is the type of case that Nehru tried to make. But that...
In other words, the Indian state is a vehicle to a particular end, and if the Constitution is an obstacle in that way, amend it.
Yes.
Your interpretation is that the Constitution embodied principles that the founding fathers of the country thought should be the bedrock of Indian democracy, and 16 months after its implementation, Nehru was prepared to play around with those principles because it suited his government to do so. In other words, those principles were not considered prior and a priority. his government's policies were considered more important than the principles of the Constitution.
Exactly. Exactly. Neither he nor his government believed the Constitution to be sacrosanct in that way.
Let's, against that background, look at some of the details and the content of the First Amendment. Your book makes crystal clear, and you said this yourself in your first answer, that the First Amendment had an adverse impact on several fundamental rights. Let's look at some of them. To begin with, you say it introduced new grounds on which freedom of speech could be curbed. What were these new grounds, and how damaging were they to freedom of speech?
So if you look at the original Constitution, the one that had been passed in 1950, the grounds on which free speech could be prescribed were limited to defamation, slander, libel, and decency and morality.
Anything that undermined the security of the
anything
state.
that undermined the security of the state or tended to overthrow it. So the bar had been set, the bar for legislation that could prescribe free speech was set very, very high. And this became apparent when cases that concerned free speech were brought to the courts. Very famously, of course, the two cases in the Supreme Court, that was Ramesh Thapar versus the state of Delhi, Ramesh Thapar versus the state of Madras, and Brij Bhushan versus the state of Delhi, where the Supreme Court declared public safety legislation used to proscribe free speech as ultra-virus of the Constitution.
So this left Nehru with the feeling that he didn't have sufficient powers to curb free speech, and he wanted more, and that was the intention behind one element of the First Amendment. I need more powers to curb the sort of free speech that the court in the case of Ramesh Thapar or the Brij Bhushan case has upheld.
Exactly. And part of the reason was because Nehru thought that the larger interests of safety and security, and in this he was supported by Sardar Patel, dictated that the state be armed with those powers.
So Nehru thought that the safety and security of the state was more important than the principle of freedom of speech. And the principle of freedom of speech could be curbed to ensure the security of the state.
Yes, and also one of the key reasons behind it was the fact that there had been plenty of trouble in Bengal because refugees had been pouring in from East Bengal, and Nehru's policy vis-a-vis that had come in for a lot of criticism, particularly from the Hindu right, who Nehru thought were essentially creating a situation which would drive him to take military action against Pakistan.
So you're saying one of his intentions in adding powers to curb freedom of speech was also to curb the criticism from the Hindu right?
Yes.
Now, in this context, you make a very important point. You say that the First Amendment went a fair way towards validating the grounds for sedition by accepting as a curb on freedom of speech the interests of the security of the state. Previously, and I think this is an important thing for me to repeat, you could only curb speech if it undermined the security of the state or tended to overthrow it. Now, you could curb it if it was in the interests of the security of the state. Why is that second concern a problem for you? Interests of the security of the state. What does it amount to?
What it really amounts to is drastically lowering the bar for testing where the legislation fits in with the Constitution. So undermining the security of the state is quite a high bar to jump over. It needs
and you have to have proof to prove
yes,
this is undermining
the security of the
but
state.
If it's only affecting the interests of the security of the state, then that word interest can be variously interpreted, and as a result of that interpretation, so many things can come under that claim.
Exactly. It massively expands the kind of window of possibility for what the state might consider to be in its interest.
So once freedom of speech can be curbed because it's in the interest of the security of the state, then you're extending the powers of the state because that state can interpret the word interest as it wants.
Yes, exactly.
Right? Now, the second thing that the First Amendment did, and you mentioned this as well, is that it adversely affected the right to property because it allowed Nehru to take over zamindar lands without paying them equitable compensation. But there are many that would have argued, both at that time and perhaps even now, that this is understandable in a poor country where zamindari exists perhaps at the cost of landless rural workers who are suffering. But as a result of amending the right to property, did Nehru also ensure that the right to property was no longer a fundamental right, that it got reduced in importance and significance?
So what Nehru effectively did, he didn't actually repeal the right to property, but what he did was he made it almost redundant, because the article that was added basically said that nothing in this right would affect government acquisition of land if it was being acquired for a public purpose. Now, the question of the courts coming in the way of this policy is that nobody really opposed zamindari abolition as a principle. Neither the courts, crucially neither the opposition, and not even the zamindar. So not even the man who led the judicial sort of fight back against zamindari abolition, Nehru's colleague in the Constituent Assembly, Kameshwar Singh, opposed zamindari abolition as a principle. And so what the court simply said was that zamindaris could be acquired, but it could only be acquired with equitable compensation.
And he didn't want to pay that level of compensation because the Indian state presumably couldn't afford it.
That isn't exactly the case. Most of the other states passed zamindari abolition. The laws went to the courts. They were all upheld. It was only in Bihar where the zamindari abolition law was struck down, and it was struck down crucially because it discriminated within categories of zamindars. So there were some who owned large zamindaris who were to be given 3 years worth of their annual income as compensation, and then there were some who were small who were to be given up to 20 years of their annual income in compensation. So it was that principle on which zamindari abolition had been held up.
And this upset and annoyed Nehru.
Yes.
And so he passed this law, which, as you say, made the right to property redundant.
Yes.
The right to property continued, but it became redundant because the level of compensation that you would get from the government if your land was forcibly acquired was minimal.
Yes.
That's why it became redundant.
Partly, and partly also because he circumscribed the power of judicial review over such cases.
But in making the right to property redundant, did he reduce the right to property to something other than a fundamental right? Because if you don't have proper compensation when your land is acquired, then your right to that land doesn't seem like a fundamental right any longer.
Entirely true. That was more or less the case.
Now, the third aspect of the First Amendment is that it introduced into the Constitution what's called the Ninth Schedule, which you describe as a compartment where laws could be placed to make them immune to judicial challenge, even if they violated fundamental rights, which means that suddenly the Constitution had an area where it was protecting unconstitutional laws. Of all the different amendments that comprise the First Amendment, would you say this, in a sense, was the worst of the lot?
In the short term, definitely yes. It was widely described as a constitutional monstrosity at the time, and there is a quip, and I have put it in the book somewhere, from Chief Justice Hidayatullah, who described it as, who once said that the Indian Constitution is the only one that requires protection against itself. And what that basically allowed governments to do was to simply evade the part on fundamental rights.
Quite right. The government hereafter could create laws that in fact undermined principles or articles of the Constitution, then tuck them into the Ninth Schedule, as a result of which the Supreme Court couldn't review them, couldn't strike them down. And so the Ninth Schedule, as you pointed out, gave protection within the Constitution to unconstitutional laws, which is why the Ninth Schedule is a monstrosity.
It is. It is. And originally it was thought that only laws connected to land reform would end up in the...
But a whole lot of others went there.
But a whole lot of others went.
Including several to do with reservations.
Including several to do with reservations, including several to do with nationalization, including several to do with security, all sorts.
I should add, for the sake of the audience, that the Supreme Court has in theory agreed to review the Ninth Schedule. It agreed to do this several years ago, but it hasn't got around to doing it. So there is a question mark that hangs over the survival of the Ninth Schedule, but we don't know when the Supreme Court will act. It's already delayed doing so by several years. But so far, Tripurdaman Singh, we've been discussing what I call the content of the First Amendment. Let's now come to its impact. We've already established at the beginning of this interview that one of the impacts was that it created the precedent of amending the Constitution each time the courts delivered a verdict that the government considered unfavorable or adverse. Did the second impact mean that this also established the tradition of using executive powers to subdue the judiciary?
In a way, yes, both executive and of course legislative, because the Congress Party enjoyed such a huge majority in the provisional parliament that there was no effective way to check it, and so the executive more or less had carte blanche to do what they wanted. And if you could amend the Constitution every time an adverse judicial opinion came, then what it did was to give the government a sort of whip hand almost over everything.
And this affects the fundamental balance of powers between the three organs, the executive, the judiciary, and the legislature. Now, with this capacity to amend the Constitution whenever you want, if the courts have given an adverse ruling, you're suggesting to the judges that, hang on, the whip hand is with us, not with you.
Yes, exactly. And to give credit to Nehru, that's something that he was quite forthright about, and he said it very openly that policy has to be decided by the government. And
so Nehru actually didn't hide the fact that the whip hand now, after the First Amendment, lay with the executive, and that if the judiciary kept giving verdicts that were adverse to the interests of the executive would act to amend.
Well, more or less, he didn't. He, of course, used the language of democracy to say that effectively the courts and the Constitution were obstructing the will of the people. But the result was more or less, as you say,
maybe
that
the
it did
word
give.
Intimidate is wrong, but did this have a sort of effect on the attitude of the judges and their capacity to stand up to the government?
That's hard to tell, but there's a very cryptic. The then Chief Justice gave a very cryptic sort of speech after the First Amendment, where he hinted more or less that any collapse or any shift in the balance of power between the three organs of the state leads more or less to authoritarianism. And I think what he was hinting at basically was that the executive was gaining the upper hand. So probably true.
There was a sense in which even if they didn't use the word intimidation, the judges felt that the pressure was on them.
Yes.
Or their room and space for action had been reduced.
Their room and space for action had been reduced. Equally, the fact that what they did could very well be overturned through a constitutional amendment. So that.
Now, some scholars like Nivedita Menon have said that a second impact of the First Amendment was that it reduced the importance of the individual in the Indian Constitution, qua caste, community, state, or class. Do you agree with that? And if it does, how important is this reduction of the importance of the individual?
I agree with it entirely. And if you look at the contents of the amendment, in each of the three tracks, in the case of freedom of speech, it empowers the state vis-a-vis the individual. In the case of reservations, it empowered community-based identities or community-based groups vis-a-vis the individual. And when it came to property, of course, again, it in a way favored the favored class as a category vis-a-vis the individual. So in all of these cases, the state empowered the First Amendment empowered certain categories, which now we can see have more or less triumphed over individual rights
and
almost
the
entirely.
individual was perceived as the entity at the very heart of the Constitution. That entity now, as a result of Nehru's First Amendment, shrank in importance.
It did, and that's again, and I quote the historian Sunil Khilnani in my book, for him to say basically individuality now became a kind of very precarious enterprise, and Indian liberalism was more or less crippled at its origins because
And this
because
was
of
clearly
this.
not what the original constitution had intended.
No. And if they had intended it, that's what they would have done. The fact that they didn't do it is a very clear indication of that they
Now,
didn't.
finally, you write in your book that the First Amendment, and I'm quoting you, opened the floodgates for drastic and oppressive laws like the National Security Act, the Maintenance of Internal Security Act, and the Unlawful Activities Prevention Act, all of which, you say, have often been used to ban books, arrest journalists, jail activists, harass political opponents. Can you explain this a bit more fully?
So in the cases of these acts, I mean, if you look at the language that's deployed, the language that's deployed is the same as the language that's deployed in Article 19.2, which delineates the grounds on which, for example, free speech can be prescribed. So because that window is now so wide, you can basically say prescribing this sort of speech or detaining somebody or arresting somebody who's acting in a manner that's prejudicial to the interests of the security of the state is something that can now be done.
So if I understand you correctly, what the First Amendment did was to widen the window through which you can determine all sorts of speech are against the interests of the state, as a result of which a whole range of speeches which previously could not be proscribed could now be proscribed. And these laws that you mentioned walked down that road to prescribe those speeches and consequently those books or those acts by activists.
These laws, but also the relevant sections of the Indian Penal Code, which had been declared unconstitutional earlier on. So that was sedition, things such as maliciously outraging religious
so
feelings.
Nehru may not have himself passed some of these acts, his First Amendment created the opportunity or the groundwork for his successors to pass these acts.
True.
So he opened a window for legislation that was much worse than that had been thought of at that time.
That's true, and Nehru made this point quite often that he himself didn't intend to pass any draconian legislation, but this was just powers that he was giving Parliament, and
But he gave the government the power to do it subsequently if they wanted to. He may not have, but his successors did.
Yes, he did, and not only did he do it, he also called it his gift to the younger generations and the succeeding parliaments.
This is why you point out that so sweeping are the changes that the First Amendment introduced, both in terms of its content as well as in terms of its impact, that the renowned constitutional scholar Upendra Bakshi actually called the post-amendment constitution the second constitution or the Nehruvian constitution. He refused to accept that this was the same as the original document. He believed Nehru's First Amendment had changed the original into a different constitution.
More or less, that's true. He did. And it had, because both in impact and in content and in long-term effects, it has, the sort of long-term effects have ensured that it really is not what was passed in 1950. The divergence is wide.
And not what the founders of the country had intended.
More or less true, again.
Now, so far, Tripurdaman Singh, we've discussed the content of the First Amendment and we've also discussed its impact. Let's now come to the rather strange way in which the First Amendment was passed. I've already pointed out to you that the First Amendment happened literally 16 months after the Constitution came into effect. And we've discussed the fact that this suggests that Nehru and his first government certainly didn't hold a great sense of commitment to a constitution that was just 16 months old, because 16 months later they were happy to amend it. But the second thing that struck me is that the amendment, the First Amendment, was passed by an unelected provisional parliament, not by an elected parliament. Isn't that rather strange?
It is rather strange, and it was not only provisional, it was indirectly elected on a very, very narrow franchise, and indirectly elected for a particular purpose that had been to frame the Constitution and then to sort of run things until a general election had been held. And that was...
So it didn't have the moral mandate to actually amend the Constitution?
No, and a lot of people, a lot of Nehru's colleagues and opponents, starting from the President of the Republic, Dr. Rajendra Prasad, believed that moral rectitude required that a good precedent be set, and even if there was a case to amend the Constitution, Nehru should wait for the first general elections to be held. Yes, exactly.
So the two things that are quite important is, first, an unelected provisional parliament amended the constitution, not an elected one. And secondly, this unelected parliament was unelected in the sense that it was elected from a very, very small base. It wasn't based on universal free vote, on universal franchise.
No.
It therefore didn't represent the people of India. It represented that very small number that had elected it.
Yes, and a very small number that had elected it for a completely different purpose.
Now, the second odd thing about the way the First Amendment was passed is that the Constitution itself clearly stipulates that amendments must be passed by a two-thirds majority in both houses of Parliament. But the Provisional Parliament was a unicameral body. The Rajya Sabha didn't exist at the time. And as you point out in your book, Nehru got around this problem by misusing the constitutional removal of difficulties order created by Article 392. Now, this is a very important point, but it's a somewhat technical point. Can you explain it in simple English?
So basically what that article, what the president was allowed to do was to make small modifications to constitutional articles, basically to get over procedural difficulties in the period between the constitution coming into force and an elected parliament, and parliament, general elections happening and a bicameral parliament being elected, because the constitution was of course written with that in mind. And so what Nehru did was, Nehru used the possibility of making minor procedural amendment changes to the constitution, and they were not really changes, they were just basically changes in the way you would understand things. So what he did was he used that to change what was written in Article 368, which
this is very important. I'm repeating it so the audience understand. Article 392 gave the government the power to make minor adaptations to the Constitution to overcome procedural difficulties. Right? But it was really meant only to help facilitate the functioning of the Constitution, yet he used this to virtually, in a wholesale way, amend the Constitution. And this power granted under 392 was not intended to amend the Constitution, it was intended simply for small minor adaptations to overcome procedural difficulties as the Constitution was functioned over that interregnum period after the Constitution came into being and before the first election happened. It was simply to help the functioning for that limited period. He misused it to do something way beyond what was intended.
Yes, so he used it to change the meaning of Article 368, which gave Parliament the power of amendment, and then used that modified Article 368 to amend some of the most important provisions in the Constitution. Crucially,
now, there's an uncanny resemblance here between what Nehru did in 1951 when he misused Article 392 and what Narendra Modi did in 2019 when he misused the powers that he has under Article 370. In both instances, those powers were used to amend another article which was then applied back. In Modi's instance, it facilitated the change of the abolition or the reading down of 370 itself, and also the reduction of the state or the demotion of the state from a state to a union territory. In Nehru's instance, it facilitated the amendment of the Constitution by what wasn't a body that was meant to amend it in the first place. But both prime ministers were accused of sleight of hand.
Yeah, I mean, that's a great way of putting it. It is a sleight of hand, and it's a mere technicality. It's using a mere technicality to achieve ends that
were not intended.
That were not intended.
I don't want to make this at all political, but it's worth pointing out one of the grounds on which Congress or the opposition as a whole criticized Mr. Modi in 2019 are precisely the grounds on which Nehru could be criticized in 1951. Both indulged in sleights of hand, both used articles of the Constitution in a way in which they clearly were not intended to amend the Constitution by amending another article first, right?
That's true, and that's one of the reasons why it's important to remember what happened in 1951, because it clearly shows us that what is happening now is not something that is new. This is something that is built into our history, that is for which there are precedents, and for which there are precedents not only legal but also political and moral.
So there are three particularly worrying aspects about the First Amendment, and we've discussed each of them, but I'll repeat them for the audience. The first worrying aspect is the actual content of the First Amendment, which ended up undermining the right to freedom of speech, the right to property, and created this ninth schedule, which provides protection within the Constitution to clearly unconstitutional laws. The second worrying aspect is the impact of this amendment on the functioning of Indian politics. It changed the relationship between the executive and the judiciary. It tended to send a message to the judiciary that if you pass orders that are adverse to the government's interests, we'll amend them by amending the Constitution. It also affected the role of the individual at the center of the Constitution, and it clearly opened the window for draconian laws like the ones we've mentioned, the National Security Act, UAPA, the Maintenance of Internal Security Act.
And sedition.
And now the third aspect, and sedition of course, and now the third aspect which is worrying is the way in which this amendment was passed. An unelected provisional parliament passed it, and in doing so, Nehru indulged in the same sleight of hand, misusing powers that were not intended for that purpose, just as Narendra Modi did in 2019 in Kashmir. All three, the content, the impact, and the manner in which the law was passed, are deeply concerning.
They are deeply concerning, and there's also a fourth aspect to it, which is the fact that it was passed against the wishes of the president, against the wishes of the speaker, and with a complete sort of disdain for the views of the opposition, simply because a commanding majority backed the prime minister. And so that is also something to remember.
So all the criticisms that we've discussed today, all of which emerge out of your book, were in fact raised at that time by the president, by the speaker, by members of the opposition. It's not that Nehru wasn't aware or Congress wasn't aware, they just ignored the criticism of the day.
Yes, and he made it quite clear in his letter to the president. Of course, he says that he more or less, in a way, tells Rajendra Prasad to basically shut up. He tells the opposition that actually great changes are going to be brought by him and his government because they represent the will of the people. And he equally tells the speaker that it is not really his job to interfere because, they're
this is in a sense the nub of it. Nehru's claim was that the will of the people represented by the popularly elected government with a huge majority is more important and will take precedence over the Constitution, even though the Constitution was something India had given itself and it was only 16 months old. It's not that it was an old constitution overtaken by time, but the claim that I represent the will of the people took precedence over the principles and the sacrosanct sanctity of the Constitution.
Exactly, and that is deeply, deeply concerning.
Let's at this point, because we're coming to the end of the interview, ask the question, what does this tell us and what sort of picture does it paint of Nehru himself? As I said in the introduction, we've got used to thinking of Nehru as the architect of our democracy, the guardian of our Constitution. It now emerges that at least in the specific instance of the First Amendment, he also is the man who first gutted the Constitution, or to use the phrase I did, he molded. That's another aspect of Nehru, one that we aren't used to, we aren't familiar with, but it comes out very strongly from your book.
So Nehru's legacy in those terms is mixed, and it's important to have a sort of honest conversation about it. There were aspects to his sort of personality that were profoundly democratic, and that included sort of fastidious attendance of Parliament, the wide consultation, etc. But a lot of this was purely performative, as the First Amendment shows. It was pedantic and performative, and what the First Amendment really shows is that at times when Nehru didn't get his own way, he could be imperious, he could be authoritarian, he could be stubborn,
Arrogant and superior.
arrogant. Exactly. But what is very interesting to note is that these are not things that Nehru ever tried to hide. He, in a pseudonymous article that he once wrote, he described
in 36.
in 1936, yes.
But what you're saying is that the First Amendment,
Mhm.
in terms of its content, in terms of its impact, and in the way it was passed,
Mhm.
in terms of all three, reflects the arrogance of Nehru,
Mhm.
that I represent the will of the people. If the Constitution is a block, I'll amend it, and I'm right to do so, because at the end of the day, I know the will of the people is behind me. That is an arrogance which runs through all three aspects that we've discussed.
Yeah, it does. It does. And
this is a side of Nehru that we haven't really fully appreciated.
it's also a side of Nehru that's been, I'd say, people have been reluctant to engage with it.
You mean they've deliberately hidden it because it contradicts the great man image?
Well, I wouldn't say deliberately hidden. I just say because
Haven't highlighted.
yes, that's a better way of putting it. I'd say they haven't highlighted it mainly because it counteracts the sort of almost hagiographic way in which
It's not
Nehru
just
is
that they
treated.
haven't highlighted it. They've deliberately forgotten all the critical issues to do with the First Amendment. Your book brings them up.
Mhm.
We've discussed them today. No doubt they were topical and critical in 51,
Mhm.
but over the next 70 years they've been forgotten.
They have, and that's again one of the criticisms that was brought in Parliament is the fact that once something happens, it becomes it sort of every step that you take on that road, widens the Overton window. So what was what was outrageous in 1951
Becomes acceptable 70 years
acceptable,
later, because you got used to it.
Yes, exactly.
And that's the second aspect of Nehru's legacy, that even though he may not have used or misused the draconian powers that the First Amendment gave the government, his successors did. And he created the opportunity for them to do so. Had he not passed the First Amendment, they might not have been able to do some of the things they did. But he made it possible.
He made it possible, and in this he showed a tremendous lack of foresight, in my opinion.
Foresight about what sort of successors would take his place.
What sort of successes would take his place, but even more than that, what sort of activities that the First Amendment would basically enable. And
he couldn't see the extent to which the powers the First Amendment was giving the executive could be misused in the wrong hands in years to come.
I think the way I'd say it was he deliberately chose not to see that, because it wasn't as if he wasn't warned. He was warned by the opposition, by the president, etc. So he chose not to see it, and the claim that
This
he
is
made...
even worse. He was aware of how it could be misused. He had been forewarned by people how it could be misused, but he deliberately chose not to see it. He turned a Nelson's blind eye.
Yes, with the claim that Parliament should be trusted, and what the critics were saying essentially, that India's Parliament could not be trusted, and he, whether for good or for bad, he basically, or at least he claimed that India's Parliament and its parliamentarians could be trusted to do the right thing, despite having the ability and the powers to not do the right thing.
This suggests either naivete on his part or something worse.
Perhaps both. I mean, if you ever read Sardar Patel's letters to Nehru on the question of sedition or on the cases that triggered the First Amendment, the impression that you often get is Patel thought Nehru to not understand how important the stakes were.
And yet, as you said, Patel supported the First Amendment.
Patel supported... Patel died before the First Amendment came into being. But Patel did hint to Nehru that some sort of amendment would be necessary because...
So Patel was on the side of the argument that if the courts are going to block our policies and reforms, that the Constitution must be amended. He may not have agreed with the details of how it was amended eventually, but that principle of amending the Constitution to overcome the obstacles the courts are putting in our way, that principle Patel agreed with.
Not entirely.
But you mentioned that at the very beginning of the interview, that Patel supported that attitude to the Constitution. You said it.
Patel straddled the boundary. So in terms of freedom of speech, yes, he supported that attitude. In terms of the other parts of the amendment,
Not the right to property, perhaps,
yeah,
but in terms of freedom of speech, Patel supported the amendment to curb it further.
yes, and Patel even described them as perhaps described the right to free speech perhaps as born out of irrational exuberance, in the flush of freedom.
That is another aspect of Patel that we're not aware of or not told about today, but let's not go into that. It's a different story. I'm coming to the end of this interview. When the First Amendment was passed in June 1951, Ambedkar was a member of the government. We now consider him today as the father of the Constitution. How come when this was happening, this monstrosity was happening, he didn't protest and resign?
Ambedkar, I feel, was straddling the boundary between agreeing with what was happening and disagreeing with it. So he did put up a certain amount of resistance.
But not enough.
No, not enough, but enough to have the word reasonable included in the provisions for restrictions of free speech.
But that clearly wasn't a sufficient bulwark to defend our liberties, because as we've seen over the years, freedom of speech has been curbed. And Nehru ended up creating that possibility. And Ambedkar did not do anywhere near enough to stop Nehru. I mean, he could have resigned, he could have made it an issue, but he didn't.
He could have, he didn't. And I think the impression that I get is that perhaps he thought on balance what he was getting on the question of reservations was worth
So he was a politician. I'm gaining on the side of reservations. If a little bit of freedom of speech is lost in the process, so be it. It's a bargain well made.
More or less, that's the impression I get. But also crucially, Ambedkar didn't have much faith in the ability of Indian society to kind of sustain democracy. And these were fears that he...
But he didn't give Indian society much chance to do so either, because he
That's
agreed
true.
with these curbs on freedom of speech.
That's true. That's true.
In fact, you used a phrase for both Ambedkar and Patel. They were straddling the boundaries. Straddling the boundaries does suggest that they don't have firm convictions and principles they want to stand by. They were trying to bridge together two difficult opposite points of view, which doesn't suggest much conviction.
To be honest, I don't think very many of the India's first generation of leaders had very strong convictions one way or another. And Rajagopalachari is a very good example of it at that point, because he was a great supporter for draconian curbs on the freedom of speech.
This is a terrible picture that emerges of the men who created India. Rajagopalachari, Ambedkar, Patel, Nehru, these were all people who actually didn't have great convictions. They didn't stand up and defend the constitution that they were responsible for creating or the principles upon which it was based. When that constitution thwarted what they wanted to do in government, they were happy to amend it. And when there was a question of standing up for freedom of speech, they thought it was, to use that phrase of Patel's, exaggerated exuberance. I mean, these men who we look upon as the greats of our foundation actually had feet that were half of clay.
Exactly. I mean, I wouldn't say that they had no convictions, but
they didn't stand up for them.
Perhaps they did. Perhaps their convictions were not what we imagined them to be.
That's even worse. That we've given them great credit for the convictions that we thought they had. Upholding the constitution, their convictions were quite different.
Yeah, exactly. Exactly.
So your book also reveals that the people we think great, the founders of India, were not quite as great as we think, or at least not for the reasons we think.
Exactly. I mean, they were great because they achieved something that...
Independence.
Independence...
Not standing up for the values of democracy and free speech.
But then there is a question as to how much they ever believed in the values of democracy and free speech.
Well, that's another even more worrying thought. If they didn't in the first place believe in the values of democracy and free speech, then it follows they wouldn't stand up for it. But it also means that we've thought them great for the wrong reason.
Exactly.
Finally, I'm really rushing you because we are coming right to the end. 22 years after the First Amendment was passed, the Supreme Court handled what's called the case of Bharti case in 1973 and came up with the doctrine of basic structure. Can the First Amendment today, 20, 50, 60, 70 years later, be challenged on those grounds, or is it now just too late?
So I'm perhaps not the best person to answer that question because I do not have a legal background. But my sense is that that is unlikely to happen. First, because the case for Bharti judgment is prospective and not retrospective. Second, also because the Supreme Court has now, to a large extent, kind of found the keys to the judicial vault that the ninth schedule sort of created. So I doubt that it would happen. Of course, in a famous article, Arun Jaitley called it, the First Amendment, a judicial anomaly in light of the Kesavanand Bharati judgment. But ultimately, how far the Supreme Court takes it is for it to decide.
And I should add that the way in which the Supreme Court has been behaving vis-a-vis the executive in the last few years doesn't suggest that the Supreme Court is likely to revise the First Amendment.
I don't think, again, that's something of the last few years. That's a trend. Whenever there is a strong executive, the Supreme Court has tended. Yes.
On that rather depressing note, we come to the end of what is, in fact, an eye-opening interview. It reveals Nehru, but not just Nehru, Rajagopalachari, Patel and Ambedkar in a light in which we are not accustomed to seeing them. And it also tells us something about the manner in which our Constitution has been amended by people who we've always called guardians of the Constitution, but they in fact are the first people to have put the knife into the Constitution. I thank you for this interview and for opening our eyes to something we were either unwilling to see or simply unaware of. Take care, stay safe.